Welcome everyone. We're going to start our IFA seminar webinar for this evening. There probably will still be a few more folks joining us, but just while we begin, it's great to be running yet another webinar for the IFA branch this year. One would have to say, to be honest, that we've been a little slow to jump on the technological bandwagon, but now that we're here full on, and we've really run several webinars during the year, starting, I think we started in May or June, and it's really been terrific, the level of audience and engagement that we've had. So I'm Miranda Stewart. I'm Professor at Melbourne Uni Law School and on the IFA Exec Committee here in Australia. I'd like to first just acknowledge that I'm hosting this webinar, if you like, on the lands of the Wurundjeri people of the Kulin Nation in Victoria, and honour their elders past and present. And I know that we've got people attending the webinar from around the country, and so welcome to any Indigenous peoples in the audience too. The event is being recorded, so we do hope to make the recording available to our IFA members on the IFA Australian branch. For any of you who are in the audience who are not members of IFA, we would love you to join us. I should highlight that normally the International Fiscal Association has a big annual congress, often in an exciting and beautiful location in the world. This year, our national reporters would have been heading to Cancun in Mexico. So we're very sorry that they're not able to go there and we're not able to see them there. But IFA is running a virtual congress online in November, over the period the 16th to the 25th of November. The Congress is free for members. So if those of you who are members, if you haven't registered, you can just go online to the general IFA website, www.ifa.nl, and register there. If you are not a member, they would be delighted if you'd like to join. And if you were to approach me or one of my fellow executive committee members, Chair Niv Tadmore, Andrew Mills, or our Secretary Paul Sokolowski, then we can join you up to the Australian branch, and that will give you free access to the IFA Virtual Congress. I must say the hours of live transmission for the virtual congress will be kind of 2 a.m. to 5 a.m. Australian time. However, everything is also going to be recorded. So depending on how much of an insomniac you are, you can either participate live or get all of the materials and recordings of the sessions, which do look very interesting. This webinar is on the topic of tax treaties. We're really pleased to have such a great panel to talk about that. We do like to have a specific treaty webinar or seminar every year or two. We've framed this particular webinar around the national report that was for this year's IFA Cancun Congress. And those of you who are members would have received the national report. I have made that national report available for people if you wanted to have it in front of you, prepared by one of our panelists, Gareth Redenbach, and Professor Sunita Jogarajan from Melbourne Law School, who unfortunately couldn't join us this evening. So if you wanted to have that national report in front of you, we've put the link to the report now in the chat. And the particular topic of that national report was called Reconstructing the Treaty Network. And it was sort of a review of the multilateral instrument as it applies to the treaty network after a couple of years have passed since the MLI was initiated. So Gareth will be taking us through some of that. So just before I pass on to Gareth, let me just introduce our panelists. Many of you will know Gareth Redenbach, who is here at the Victorian Bar, barrister specialising in international tax. Gareth also teaches with us as a senior fellow at the Melbourne Law Masters, and has been a long-standing member of IFA, always interested and engaging contributions on international tax issues. So Gareth and Sunita Jagarajan were the two reporters to that 75th IFA Annual Congress. Then we also have, to make some comments, another person who probably needs no introduction, Professor Richard Vann from the University of Sydney, long-standing expert in corporate and international taxation. And I hadn't realised, but it does look like Richard's been focusing heavily both on the past and the future of tax treaties. One of his recent publications being Writing Tax Treaty History, which of course was also a special area of Sunita Jagarajan's. So Richard will be bringing that perspective to our Australian, thinking about our Australian treaty network. And then we're really pleased to have Greg Wood from Treasury with us again. Greg's given us the Treasury perspective on tax treaties in the past. Greg's responsibilities are somewhat broader than treaties now, so we're grateful for his time. He's currently a manager in the Corporate and International Tax Division of Treasury, but has had a long-standing engagement in tax treaty negotiations and as a delegate to the OECD, and was one of Australia's delegates to the ad hoc group on the multilateral instrument. So look, without further ado, our plan is to have each of our panelists speak for a short period of time, sort of 10 to 15 minutes, to introduce some key issues and themes, and then we will have time for open it up for plenty of Q&A and discussion in a sort of a normal IFA seminar style. So if you do have questions, you can put them in the Q&A and I will see those. And or you could even use the chat function. Okay, so with that, I might hand over to you, Gareth. Thank you.
Thank you, Miranda. So the first thing I do want to say is that a very large amount of work on the report on reconstructing the treaty network was done by Professor Jagarajan, who can't be with us today. And I think it says something about the esteem in which he's held, that if you can't get Professor Jagarajan, you get Professor Vann. And if you can't get Professor Vann, presumably you get the ghost of Klaus Vogel at some point. But so it should not be the thought that Professor Jagarajan did any less than the vast majority of the hard lifting on this report. That said, there were some very interesting things that came out of preparing this report. And this report, in typical IFA fashion, was prepared basically, well, it had to be finalised 12 months before the conference, which then had to be finalised in October last year. And that meant the draft had to be finalised about 9 months before that. So what it really represents is a summation of what people were thinking about the MLI when it moved from being something that was potentially happening in the future to something that had happened and suddenly people were coming to live with. Now, a large part of the report deals, for an Australian audience, with matters which are relatively straightforward. For example, how treaties are incorporated into Australian domestic law, how many treaty partners we have, the extent of differences between our standard model treaty and the OECD model, and to a lesser extent the UN model. Now, I'll take that as read for this audience, but that section of the report fulfills an important part for IFA, which is allowing people from places that aren't Australia to pick up the report and understand pretty quickly where the Australian jurisdiction comes from in terms of its legal history and what underlies the basis of our treaties, so that they can understand how relevant the MLI is. Now, where I think it gets really interesting is in the second half of the report, because at that point we're dealing with not just the history and context of Australia's adoption of the MLI, but essentially what the adoption of the MLI has meant within Australia. And again, I caveat this by saying the comments essentially reflect a December 2018 view of what the MLI meant, and so it would not capture the last 18 months or so. But I thought there were a few really interesting things coming out of it. Now, the first of those was for about 3 years before the MLI was introduced, the sky was apparently falling. And the sky was falling because the definition of a principal purpose in the principal purpose test was potentially broader in terms of obtaining a treaty benefit than the Part 4A test of sole or dominant purpose of obtaining a tax benefit under Australian law. And there are a lot of people, and I'll happily include myself in this group of people, who started saying, well, a principal purpose is potentially different to the Part 4A test of a sole or dominant purpose. And in writing the report, we interviewed quite a number of people who directly had to deal with the issue of treaty shopping day to day. And these included QCs at various bars within Australia. It included leading international tax practitioners at accounting and law firms and academics. And it seemed to be that everybody had decided at some point after the MLI was signed that a principal purpose would tend to be interpreted in about the same way as sole or dominant purpose within an Australian law context. And that was interesting because prior to the MLI being signed, there seemed to be a consistent theme amongst at least the advisory community that this would be somehow more uncertain than the use of Part 4A to deny treaty benefits in particular situations. It seems that about 12 to 18 months after signing, everybody had decided maybe that's not such a big issue after all. And I thought that was interesting because it reflected a kind of a consensus view that perhaps the MLI GAR was not more broad-ranging in practical terms than the existing use of Part 4A. I can say on an anecdotal basis, it appears that there hasn't been a sudden upswing in assessments or amended assessments being talked about in terms of a treaty shopping denial under the MLI in future years rather than the use of Part 4A. There are a number of treaty shopping cases I've heard of that are on foot. It doesn't appear that even those in the current year, MLI's PPT is considered more of an issue than the application of the general domestic GAR to deny an Australian tax or tax benefit. So that was out of the notion of reconstructing the treaty network, possibly the most surprising thing, I think, at a subjective level, but no one seemed as concerned about it after implementation as they did before implementation. The other point, now the point that caused much more consternation after implementation than before was the residence rule. And in particular, the fact that if you're a dual resident of Australia and another MLI jurisdiction as a corporate, then you could be denied treaty benefits absent mutual agreement between the parties. Now, one of the thing that we concluded in the report is this was probably, rather than a problem with the MLI, a function of the Australian domestic law. And in particular, it was a function of the decision in Bywater Investments, which meant everybody was suddenly concerned they had dual resident companies because you potentially had central management and control in Australia while also being resident of another country. Now, that concern, which we found very interesting, may have been ameliorated to some extent by the recent announced changes to the definition of corporate residency as a result of the 2021 budget. But it also very interestingly led really quite quickly to the introduction of what I think is the first bilateral administrative guidance issued by the ATO and the New Zealand IRD about taxpayers being able to self-assess for certain SMEs the effective place of residence, so that they're allocated under the treaty and hence could claim treaty benefits in Australia or New Zealand. And that was something which I thought, and Professor Jogarajan thought, was just fascinating at how quickly the ATO and NZIRD moved to ameliorate that concern on a domestic level for at least SMEs. You could claim there were many problems with the administrative approach taken, or it didn't cover enough people, but it did actually show a genuine commitment to bilateralism as a result of multilateralism, in an area where bilateralism has been, quite frankly, wholly absent for a very long time, other than agreeing the actual treaties. So they were two of the things that really came out as particularly interesting. The other one, which I'll mention without getting into really wonky issues about how to interpret a tax treaty and how the MLI sits as a supposedly separate agreement to existing covered tax agreements. But the other article of general interest was the treatment of, or the availability of effectively derivative treaty benefits through a fiscally transparent entity, where the recipient of the funds, or the ultimate beneficiary of the funds, sat in an MLI resident jurisdiction. People thought that, or people seem to think that Article 3 in the MLI for transparent entities does provide much greater scope for entities to claim treaty benefits through interposed fiscally transparent entities when compared to, say, the approach in RCF 4, where we have an odd situation where 5 judges of the federal court have told us that the benefits of a treaty can potentially be claimed through an interposed entity in Australia under a tax determination issued by the Commissioner, and that any treaty benefits claimed generally or otherwise as derivative treaty benefits must be claimed at the recovery stage rather than the assessment stage. And that's a fairly large mass of words to say that hopefully Article 3 is a little more straightforward, and that it'll be relatively easy to make treaty claims, particularly for financial investors and fund investors into Australia via Article 3 from an MLI compliant jurisdiction, rather than via the somewhat tortuous route we have trying to apply ATO rulings to through limited partnerships in order to claim treaty benefits in Australia. So that were kind of the big things that we took out of it as authors. And I'm coming up on, I believe, just on 10 minutes, and I'm aware that Professor Van and Greg Wood are following me. So I'm going to do the correct thing of being quiet and letting the adults in the room speak.
Oh, well, thanks, Gareth. I think you've actually come in ahead of your time, but we can always circle back to you in particular about there were some of the other issues, I guess, arbitration, these other things people know about in terms of the MLI, but perhaps we'll circle back to you in discussion. Before we do that, though, I did want to ask you, do you have a kind of overall, having looked at it, I guess you haven't applied it in any cases or anything yet, right? But having sort of looked at it and looked at the treaties, do you have an overall conclusion about the MLI and the impact it's made? You know, big, small, irrelevant?
I don't think, it's certainly not irrelevant. I'd say it's a big impact in terms of the effectively international view that it seems revenue agencies are taking. And again, I refer back to the IRD and ATO kind of joint administrative guidance on that point. I thought that was fascinating, that it seems to be a reflection of the fact that we live in a much more global tax world than we used to. Apart from that, I would say that the impact has probably been much more business as usual than we otherwise would have expected. There's less sky falling and less areas of concern than you perhaps would have thought for something of this magnitude. But that also could be a reflection of the fact that these things take literally 5 to 10 years to move through the tax system to a point where any dispute becomes truly public.
Yeah, I guess that's right. And if Australia was already on the path with our bilateral treaties for a considerable amount of the content of the MLI, at least some of it, then it perhaps wouldn't have such a different effect for us. Okay, what I'm going to do is pass to our next panelist. So actually, I'm going to pass to Richard next, unless you would prefer to go last in our running order. I see we've put you second, so I am going to put you second, Richard, for any comments, either the MLI or just more generally on the treaty network for Australia and future directions.
Thanks, Miranda. I'll just share a screen. Can people see that?
Yes, that's fine.
Okay, so so I've entitled this "The Future of Australia's Tax Treaty Network" rather than the international network, which was the subject of the EFA Congress topic. And that's because, let me see that it's going to work. Somewhat surprisingly and hard to find, our budget this year announced, and it was in the lower taxes glossy on COVID recovery measures, that as part of getting us out of COVID, we're going to refurbish Australia's treaties with key strategic partners where necessary to maximise the benefits for Australia's economy. So I think the topic tonight is going to have, beyond the MLI, some potentially quick relevance to Australia. We probably are not alone in this, and a number of other countries may be looking at getting out of COVID and maybe freshening up their treaties. Now, Greg is the person to talk about this, not me, but I understand there's money for it in the budget and for a project on this, and that it will involve setting priorities for negotiation and streamlining the negotiation process. Traditionally, treaties take a year or two to negotiate, typically 2 rounds of negotiations, 1 in each country, and then it's got to get through Parliament. So it's a fairly slow process, but now that we're all on Zoom and we all see each other daily without ever seeing each other really, there obviously are, for future negotiations, one suspects going to be a lot more digitalised than they've been in the past. So what I wanted to do, I'll pick up one MLI issue, which I think perhaps more than Gareth said is a significant problem in practice, at least in my experience, but also just suggests some things that may be worth picking up in a reconsideration of our treaty framework. Australia is kind of out there a bit amongst countries in having a lot of provisions in their treaties which do not follow the standard wording in the OECD or the UN model. Largely, as John Taylor discovered when he did a thesis on this, sort of going back to the dim, dark ages when Australia was first negotiating treaties in the 1940s and 1950s, and some of them are still with us. And that's given us a bit of a reputation, and I meet treaty negotiators from other countries around the world as being difficult to negotiate with, not because we're not nice people, but because we ask all these other countries to sign up to things which they tend to think, well, that's not a standard treaty provision. Can you tell me what it's about? And at least if you look at the protocols to the Japan and Israel treaty, it's very clear that the Israelis and the Japanese were somewhat mystified by a number of these other provisions, and they asked us, well, can we write down in the protocol exactly what you're trying to get at here? Now, a classic example is our treaty sourcing rule, which up until the Israeli treaty was being standardly included in our treaties. Many other countries, as you'll see in the Tech Mahindra and Satyam cases, were somewhat mystified by this rule. There were widely divergent opinions in Australia about what it actually did. The courts have now settled that, I think, correctly, but it was a rule which said, well, if we can tax it under the treaty, it's sourced in Australia under domestic law. Well, I always thought that if you're going to have a rule about source under domestic law, it should be in domestic law. And we had to explain, I'm not sure how we did it, to other countries, no, we're going to put this in the treaty. And I suspect it was one of the kind of things that other countries were somewhat bemused by. That's now been solved, at least as I understand it, because we've put it in domestic law as a result or as part of the implementation of the Israeli treaty. And we, in future, won't have to explain to the other country, this is why the provision in the treaty is there. Presumably we'll tell them we have a rule in domestic law which says anything we can tax under the treaty is sourced in Australia. But that's a kind of example which has been before the courts, and the Indians in those two cases, Satyam and Tech Mahindra, the same company in both cases with a different name, but they believe fervently that this thing can't give you taxing rights which you otherwise wouldn't have under domestic law. And that's been the issue. Now, it's not clear from that budget announcement whether we're going to look at big policy issues, big treaty policy issues or not. I suspect maybe not if we're trying to do it quickly. And we did do our treaty policy back in the early 2000s in the review of international taxation. Now, there are some areas where I think our policy is pretty clear. It produces variations from the OECD language, but we should never give up on them. So our right to tax foreigners who are exploiting our natural resources, our minerals and so on, I don't think anyone suggests, oh, well, we should let them use treaties to try and avoid paying Australian tax on the profits they're making from exploiting those resources. And so we've got variations in the articles on the slide, but I would be very surprised if we ever thought of limiting our rights in those areas. And in fact, it's probably the other way around. Maybe we should be looking at extending it. And I've given the example on the slide of the telco spectrum. We go out of our way in domestic law, both regulatory and the Agreements Act, to say anyone who owns spectrum has to have a PE in Australia or be a resident of Australia. And if they don't, we'll deem them to have a PE in Australia, any foreigner. And yet we don't then protect that. Well, what happens if a foreign company owns the spectrum or a foreign company owns a subsidiary which owns the spectrum, and then they sell the shares up the line? Okay, we don't have any rule which protects our taxing rights other than Part 4A or the principal purpose test maybe going forward to ensure that we can tax profits made on telco spectrum. India has been fighting in its courts for the last 20 years with Vodafone over this issue. It just lost an international arbitration, but it's not going to lie down from all reports. The one, I think, problem we've got with the MLI is the one that is already referred to, the dual resident tiebreaker. I've seen lots of cases where this causes all sorts of problems, both for treaties, but then because our consolidation regime and some of our other rules pick up treaty tiebreakers for domestic law purposes, it creates problems in those areas as well. I think we'd be much better reverting to what we did in our New Zealand and German treaties rather than making it purely discretionary, and maybe even withdraw our, just to provoke Greg, our reservation on Article 4.3e, because I've had people at HMRC say to me, we want to give treaty benefits to Australian companies operating in the UK who are dual residents now because of what's gone on with Bywater. And we can't, because Australia put this reservation on which stops us giving discretionary benefits if we can't agree on where that company is a treaty resident. So there's a fallback position in the MLI which we excluded, and I would think it's a good idea to adopt that. Now, I don't want to take up too much time, but just to give you a kind of sense of that point I was making before, I've listed here, just out of the Israeli treaty, provisions which are non-standard treaty provisions, and these are the kinds of provisions which countries like Japan and Israel were sort of scratching their heads over, and in a number of cases, and I've referred to the Israeli protocol here, where particularly paragraph 13 of the protocol is very odd. I've never seen it in any of our treaties. They say, these are things that Australia wanted in the treaty, we didn't want to have anything to do with, and here's a list of them, but they're in the treaty. Now that's a kind of odd provision to find in the protocol, but I think it was reflecting this quiet. And my concern about it is that the more you have to explain to another country and justify a departure from a standard provision, if there's not a lot of policy substance in the deviation, is it really worth it? Because you have to spend negotiating capital to get the deviation. And some of these you'll find in pretty well all of our treaties. So I won't go through them all, but I just sort of, in each case, I sort of look at them and think, I think we could either handle this in another way, like putting it in the Agreements Act, rather than putting it in the treaty, or are we really achieving very much with the provision? So the OECD has a typical OECD wishy-washy definition of residence, which has its own issues, but we always insist on putting a direct reference to our domestic residence definition rather than the OECD wording. And that has its own problems, different ones to the OECD, but do we really need to do that? What's wrong? What's the problem with the OECD language, which slowly has been creeping in part into our treaties, but still hasn't got there fully? The trust PE provision, which many people in Australia still are confused by, in Article 7, which says if the trust has a PE, the beneficiary has a PE. Now, the OECD commentary nowadays says the same thing, without the need for a provision. So you start to say, well, do we need to include that? In Article 9.1 on our transfer pricing rule, we add these words, dealing wholly independent with one another. So it says independent enterprises, and then we add in dealing wholly independently with one another. You'll see in paragraph 4 of the protocol with Israel, what we mean really independent. Does that achieve anything? Because my impression from talking to other negotiators is you have to, you have to explain to them, you have to spend some negotiating capital, and maybe you want to keep that for the issues where you're really maybe butting heads, say over natural resources or whatever. And I've got a few other ones mentioned there. The mysterious provisions in our treaties about if there's not enough information to make a transfer pricing adjustment, we can do it under domestic law. They date back to the 40s, okay? And there was a reason for them then, because we didn't actually have a transfer pricing provision of the traditional kind in our domestic law. We had other provisions. Since 1982, we've had pretty standard transfer pricing provisions. I wonder whether we need to still be putting those words in our treaty. So I think this would be a great opportunity to simplify our treaties by asking that question. Do we need to change the standard language? Because I think by going to OECD language, you will be able to do things much more quickly, unless there's some really important substantive policy issue at stake. I'll leave it there. Thanks, Miranda.
Thanks, Richard. We might get you to stop sharing your screen, although that list is very interesting. I'm sure perhaps we could use those slides and we'll put them up and make them available just so people have that little list.
Sure.
For the future. We'll go on to hear from Greg, the government perspective. Thank you, Greg. Whatever you can tell us, I guess, about the budget announcement, if there is anything about the Australian approach to MLI, 2 years later. I guess maybe we're nearly 3 years later, technically speaking. So pass on to you. Thanks, Greg.
Thanks, Miranda. And I won't be provoked by Richard. I just thought I'd also give a bit of an overview of the MLI progress so far internationally as well as domestically. And apologies if this duplicates some of the content in the paper, but I think it's probably useful context. So far, 94 jurisdictions have signed the MLI and 53 of those jurisdictions have ratified it. So that's roughly a 50% ratification rate. Over a 3-year period, that's not bad going, I think, for a multilateral treaty, and it really does demonstrate a lot of political commitment by the countries and the jurisdictions that are members of the Inclusive Framework on BEPS, which is part of the BEPS project. Now, Australia signed the MLI in June 27, and we ratified it in September 2018. And it entered into force on the 1st of January last year. At this stage, 33 of our partners, our treaty partners, have signed the MLI and nominated their treaty with Australia as a covered tax agreement. So that's important because, as people probably realise, you do need that match in order for the MLI to take effect. But the MLI won't modify at this stage 12 of our treaties. And they are treaties with Germany and Taiwan. So we didn't nominate either of those jurisdictions when we indicated our list of covered tax agreements. Austria, Sweden and Switzerland signed the MLI but didn't nominate their treaties with Australia. So there's no match there. Kiribati, the Philippines, Sri Lanka, Thailand, the US and Vietnam haven't signed the MLI. And Israel, the treaty with Israel was signed following our signature of the MLI, so it's not affected by the MLI, essentially. Now, even though, excuse me, even though we have quite a large take-up of the MLI, I would say that the take-up of all the articles within the MLI is quite mixed. So some countries would have only adopted the minimum standards, whereas other countries went a lot further in adopting the majority of the rules contained in the MLI, and we're in that category. We decided that we would adopt the MLI as broadly as possible And there are only really 2 substantive articles in the MLI that we haven't adopted multilaterally. They're referred to in the paper, but I should just point out that one of those is Article 12, which deals with dependent agent PEs. We didn't adopt that article through the MLI, but we have adopted it bilaterally in our treaties with Germany and Israel. So we don't have any real policy objection or objection to the policy, but it was just something we thought would be better implemented on a bilateral basis rather than a multilateral basis. Now, turning to the budget announcement, other speakers are correct. It is a little bit hard to find in the budget papers. Normally our stuff appears in budget paper number 2, and that's where I expected to see it, but I went looking for it and couldn't find it, and I thought I was losing the plot, but it is actually in one of the glossies, which is just one of the brochures that accompanies the budget papers. And it's actually an expense measure. So what's happening is Treasury is receiving funding from the government to basically ramp up its capacity to negotiate more tax treaties and to renegotiate existing tax treaties. And if you look at the glossy, it's the one titled Lower Taxes. You'll see that the message around that announcement is all about encouraging investment. So we're talking about sort of stimulating international investment into and out of Australia. So it's got that sort of recovery element to it, I guess, economic recovery element to it. Now, part of the reason for that is that we have a relatively small treaty network. By OECD standards, I think we're 2nd or 3rd from the bottom in terms of the number of treaties. We have 45, and quite a few of those are quite old. So I think that the oldest treaty that's still, at least part of it is still operational, is the treaty with Singapore, which dates back to 1969. It has been amended, parts of it have been amended since then, but there are still quite a few provisions in there that were part of the original treaty. Also, we have treaties with a few countries, China, Indonesia, Ireland, Korea, and the Netherlands, and they haven't been updated this century. So, you know, that's more than 20 years longer, in fact, for some of them. So it's part of the problem that we always face with treaties. Not only do you sort of think about which treaties you might like to, which new treaties you might like to negotiate, but you've also got to maintain your older treaties. And that's, they don't get any younger, and policy positions change over time. So we end up with quite a bit of inconsistency throughout our treaty network. Sort of took my own snapshot of the number of treaties that we have signed in previous decades. And so, for example, in the 1980s, so 1980 to 1990, we signed 17 new treaties. In the 1990s, that number dropped to 14. In the 2000s, that number dropped to 9. And then so far, from 2010 until now, there have been 5. So if you sort of presented that as a graph, it'd be a pretty clear downward trend. That decade isn't over yet, but I can confidently assure you we won't be signing any more treaties between now and Christmas. Now, having said that, that may not be quite as bad as it sounds. We have 45 treaties, which is a relatively small number, but it probably does cover the vast majority of our inbound investment. So from an economic perspective, our network still sort of is arguably quite useful at attracting investment. Now, just going back to the budget announcement, so there are a few factors that we need to consider when we're sort of developing this work, and the budget announcement that's in the glossy is pretty much all there is at this stage. So the government has agreed to give Treasury funding commencing 1st of July next year. So from the 21-22 financial year, the funding is $3.9 million. and that's to improve Treasury's capacity to negotiate new treaties and renegotiate existing treaties. And part of the process of doing that is that we need to think about a few factors. We need to consider how best to prioritise treaty negotiations between potential treaty partners. We received quite a lot of requests from other countries to negotiate treaties, either brand new treaties or renegotiate existing treaties. So we do need to develop a framework in order to prioritise those countries. Now, we have done that in the past. We've had treaty negotiation programs previously, but we do need to go back and revisit the criteria that we've been using previously. So, the factors that you might look at would include trade and investment levels, whether or not the other jurisdictions' tax system is compatible with ours, and whether or not we have existing most favoured nation obligations with particular countries. I think we have about 8 outstanding MFN obligations at the moment, so we do need to take those into account. We also need to revisit our model. So we do have a model treaty, but it's not published. I think most countries don't publish their model. The US does, of course, but we're with the majority of countries that don't. And exactly the sorts of things that Richard was talking about earlier, we will need to turn our minds to, do we need to move closer to the OECD model? Do we need to get rid of some of those departures, which can be irritating in negotiations? Richard mentioned that they burn negotiation capital, which is true. They also burn time. Typically, a round of negotiations would last 4 or 5 days, and they can be quite slow going. And if you're spending, half a day on something that in the end is not all that important, you've sort of wasted, 10% of your week basically doing that. So we are very conscious of the fact that we do need to have a closer look at the extent to which we depart from the model, either in the form of a reservation or just, language variations and so forth. We also need to look at how we can try to streamline the implementation process. Richard also mentioned that it does take a long time for us to implement our treaties, and that is true. I think we're one of the slower countries in that regard. So the negotiations can take a year, sometimes longer, to conclude. Then we have to go through our parliamentary process, and for us, that has 2 elements to it. Firstly, our treaties get examined by the Joint Standing Committee on Treaties in Parliament, and typically that process takes 15 joint sitting days. So in reality, that spans out to 3 or 4 months of parliamentary time. And then that committee looks at our treaties from a national interest perspective, and assuming the committee recommends that we go ahead and ratify the treaty, it's only then that we generally introduce legislation. So legislation itself can take, usually takes at least 2 sittings. It can take longer. So we've got that sort of double element to our implementation of treaties, which it would be good if we could shorten that. But at this point, it doesn't seem that easy, but we're certainly prepared to look at ways in which we might do that. And the other issue that we'd be looking at as part of this proposal is our own capacity. How many treaties can Treasury feasibly negotiate at any one point in time? There are a couple of ways you could look at this. We could devote all of our resources to a single treaty and try and get through that as quickly as possible. And I think a good example of that was when we negotiated our treaty with Japan. Well, it's about a decade now ago. That was done in pretty quick time by our standards. I think it was sort of done start to finish in about 12 months. And that involved quite a lot of goodwill on both sides to sort of make that happen as well. So we could take that approach where we just focus on a single treaty and don't look at anything else until we knock that one over. Or we could maybe look at 2 or 3 treaties simultaneously and try and sort of juggle those. hopefully with that additional funding, we may get some additional resources, so we may be able to sort of take that approach. But from our perspective, building our capacity to negotiate treaties is very critical to us. If you look at treaty negotiators in other countries, a lot of them have been doing this sort of work for a long time. So it's the sort of job that tends to attract people for years and years. And that's not always the case with people who work in Treasury. They like to move around. A lot of them are economists. They don't necessarily have a tax background. So it can be difficult sometimes to attract people to that job and to retain them for any sort of significant length of time. And adding to that as well, we've also lost quite a bit of our own expertise over the last 5 years or so. We've had some senior people who were very strong on treaties and had a long history in treaties, and one by one they've left Treasury. So that's not made our job any easier. So I might just stop there for the time being and see where we end up.
Great. No, thanks very much, Greg. It's always very interesting to hear that insight into the actual process. And, you know, what you say accords with sort of what I've observed, but of course I'm always observing from the outside. I might ask you a question and then perhaps put it to the panel. I've got one question in the Q&A. So again, I wanted to just let our audience know if you've got particular questions, whether they're on a particular treaty provision or on this broader, you know, approach to treaty negotiation or Australia's national position on any of these things. That would be interesting to hear from you. I'm sorry that because this is a webinar format, you'll be coming through the Q&A rather than in a sort of meeting style comment format, but please do put in your comments or questions and I will relay them to the panel. The question that I have, I guess, for you first, Greg, but then also perhaps for Richard and Gareth is, you know, I am always back in this question of how important are bilateral treaties? And it's a bit chicken and egg as well, because of course, as you said, our numbers are much lower than many other countries, and they have been, you know, more or less for a century. Perhaps it's a bit less than that in terms of the real history of substantial treaty negotiation is really kind of post-World War II. But we do an awful lot in our domestic law, you know, both to assert taxing jurisdiction and then to relieve double tax or, you know, provide exemptions. And I guess that then goes to a related question, which is if treaties are important and if potentially if they're important in driving investment, it might be that it looks like our treaty network covers our investor countries because, of course, they want to invest through jurisdictions that have treaties. So it's a little bit endogenous, right? So if we were to broaden that treaty network, maybe we would be broadening our investment network as well. I mean, perhaps that's the goal of expanding treaty negotiation, in which case that would suggest we want a kind of a multiplier effect. We might want lots of treaties. We might actually want to kind of have 10 more than we currently do, or 20 more, which would be kind of a big step up from the current speed at which we negotiate. So I'm sorry, I've packed a lot in there, but do you have a comment, Greg, about this issue of how important are treaties?
I guess my simple response to that would be they are important because, yes, you can create similar rules in your domestic law, but then you can also change your domestic law in the future. So treaties, because you have two countries agreeing on a set of rules, the treaty cements those rules and provides a lot more certainty for taxpayers. It's a lot harder to change a treaty than it is to change your domestic law. And I think that's the main reason why business likes treaties, because of that certainty and the fact that they can't be changed easily.
And does that then imply, I'm going to come to you, Gareth, because I can see you've got a thought, but Greg, does that then imply that we should be really looking at expanding that network, or is that something you're not sure you can comment on?
Well, I can't comment too much. It's not our decision, it's the government's decision on who we negotiate with and how many treaties we negotiate. It's probably fair to say that some of the countries that have much larger treaty networks than we do have probably signed treaties for non-tax reasons. So a lot of treaties may get signed for just to enhance international relations and for diplomatic reasons. We tend to focus, with a couple of exceptions, I guess, but most of our treaties are or were signed for genuine economic reasons. And that's where we sort of distinguish ourselves from some other countries. We sort of don't have this large bag of treaties with countries that we don't do a lot of business with, so to speak.
Gareth, were you going to jump in there?
Yes, I was going to say, Miranda, I think your question reflects the Professor Peter Harris view of the world of treaties as dark matter, and perhaps in a liberalised and globalised economy, they're not as relevant as they were. And what I want to say about that, and I can say this because I'm not employed by a government agency or any organisation, is that tax treaties tend to lag the rest of the world, or the economic world, or the real world, by at least 5 years for the reasons Greg outlined, and realistically up to 10 or 20 years. And if you look at the development of the current network of double taxation treaties before the MLI, they reflected the balkanized kind of economic state of the world very much post World War I. And that's explored by Professor Jogarajan's book, Double Taxation and the League of Nations. I think it's pretty easy to say that we're standing on the eve of a post-unipolar moment in a foreign affairs sense, and possibly a new balkanization of the world economically. So I think it's probably unfair to say that treaties aren't relevant in the current environment, because given how international trade flows seem to be moving, they're probably going to be more relevant than ever in about 5 or 10 years' time. And that's probably where we should be thinking of our treaty network in terms of, not in terms of we've just signed the MLI and everybody's agreeing on things, but potentially for a fractured trade future. And again, that's not a legal comment, that's just a general kind of observation about the state of affairs of global politics.
So perhaps Treasury's role is this future gazing to try to work out, which are our next 10, both the existing partners and the new partners who are going to drive that future investment. So good luck with that exercise, Greg. Richard, did you have any comment on my general question? And then I do have some Q&A that I'll pass on to the panel.
Well, just pursuing what was being said by Greg and Gareth, we're going to have another 1 or possibly 2 multilateral treaties coming up if BEPS 2 gets off the ground. And at least as I understand it from Greg and others, the MLI is one reason why that decade just gone by has been the lowest number of treaties. If you added 33 to the number through the MLI, you might say, oh, it's our best decade ever. So I think that's, and it's not in our control, of course, it's a global decision, but I think that's obviously going to be something that Treasury is going to have to be thinking long and hard about, that if BEPS 2 gets up and we're going to have 1, 2, whatever the number of treaties that are going to be required to implement it, how is that going to affect the priorities? And it may well be that it unfortunately pushes bilateral priorities into the background again.
Yeah, I suppose that's always a risk, isn't it? I'm not sure. Look, why don't I go to some Q&A, and then Greg, if you had a response to that, that would also be interesting. Our first question, Fred Schenk in the audience asking about Bywater. So this is obviously a good question, Fred, and I think this is the reason why we have the corporate tax residence reform proposal in the budget. How does Bywater reconcile with Malaya shipping and current treaties? I think that's the problem. So I guess the proposal is to reform the in the budget, but I got the impression from what Richard's saying, we're still seeing issues with the MLI dual residence issue. Does anyone want to comment further from the panel on the direction of reform for corporate tax residents or the issue there?
Yeah, I'll just open with a comment on the Bywater decision broadly and let Greg talk about the reforms. But I personally think from a strict legal perspective, Bywater is relatively confined to its facts. And that's because the facts in Bywater were so against the company being, actually having central management control outside Australia, that it was a logical decision. And the shorthand is bad facts make bad law. And I think Bywater is a good example of that.
Greg, I'm not sure if you can comment about that other reform proposal in the budget where we actually did have that proposal to change the definition of corporate tax residents.
Yes, I can say something. So the proposal hasn't been fully developed yet. So all we have is the announcement. It's the government's legislative program is very full at the moment. So we need to get a slot in the program to introduce that legislation, and I'm guessing that won't happen this year.
There are only 6 weeks to Christmas, I think, Greg.
That's right. But
shopping weeks for those of you in Melbourne, the shops are open.
The proposal that was announced in the budget essentially reflects recommendation 1 of the Board of Tax's recent report. So the government asked the Board of Tax to do that report and agreed with the board's main recommendation, which is the only recommendation I think that requires any legislative amendment. The other recommendations don't require legislation. So that's essentially how we've come up to this point with this measure.
That's right. Richard, do you think that if that reform is done, and I'm not sure whether it's a reform of corporate tax residents taking us forward to something slightly new or whether it just takes us back to where we were before, but do you think it will solve that MLI residence problem that we're seeing in practice?
No. It will take us both back and forward, because the board was saying they want more recognition in the explanatory materials of the impact of technology on board meetings and so on, and whether that's the right focus. So I think we will go back to the 2004 ruling, which was the sort of the main object, but there'll also be, it's a different world now to 2004, so it'll reflect that. But I don't think it solves the problem, because it only applies to companies which are incorporated abroad and managed and controlled and have some core commercial activities in Australia. Now, most countries, including Australia, have at least one rule for a corporation residence, which is place of incorporation. So there's every chance that for all the companies whose residence in Australia is not solved by the amendment, because they do have some core commercial activities in Australia, they will be a dual resident for treaty purposes. To the extent the MLI changes our existing treaty, they're worse off than they would have been without the conjunction of the Bywater case and the MLI.
So I suppose that discretionary comes back to that point about the ability to use discretion among competent authorities to resolve conflict if one has to do that, and whether that is a good idea to soften that or remove that reservation, as you mentioned, Richard. Our next question is from Robert Gordon. Hi, Robert. It's about that deemed source rule, I guess, in the treaties now in our legislation. Does the deemed source rule in treaties that allow Australia to tax really make sense when a non-treaty resident would not be taxed by Australia because the income isn't sourced in Australia? i.e., you might be better to invest in Australia through a non-treaty resident rather than a treaty resident. in some circumstances. Does anyone want to respond to Robert's observation there? Look, we have plenty of non-treaty partners out there because we only have treaties with 45 countries. So, you know, the options there, of course, for taxpayers.
Yeah, I'm happy to say I agree with Robert. It was always a strain. I mean, it was Mitcham's case which mainly gave rise to this rule, and Mitcham's case was a case on domestic law. So it's always been, to me, the first best is to change domestic law and do like the US and have statutory source rules. And Treasury has looked at that in the past, but it's gone nowhere. But, you know, I mean, yes, you know, so like Hong Kong, you were saying before, Miranda, I think before we went to air, that, you know, why don't we have a treaty with Hong Kong? Well, be careful what you wish for. If you're in Hong Kong at the moment, you haven't got the source rule working against you.
Yeah, that's right. They might be better off without it at the moment. I might go to our next comment, which is about the PPT. So maybe we'll start with you, Gareth, on this one. So it is about the MLI. So of course, what we did in the MLI was enact that principal purpose, adopt the principal purpose test in general. And the question is, how does that principal purpose test impact on the main purpose test that we have in some of our older treaties, like the UK treaty? I'm not sure, Gareth, whether you want to comment or... Yeah.
So I think you're either asking a very simple question or a very complex question. The simple question is, how does it impact on the practical usefulness of the main purpose test? And the answer to that is, I think it means the main purpose test is probably never going to be used in practice because a principal purpose is a more liberal test for a tax authority to deny a benefit. Now, the very hard question you might be asking is, how do the existence of those two tests within the same covered tax agreement as modified by the MLI interact so as to impact on each other? And that is the sort of question I mentioned at the start. There are some really wonky interpretive issues coming out of the reading the MLI alongside each covered tax agreement. That's the sort of example where I think you can offer no reasoned comment without looking at the facts for a particular taxpayer, because the answer is maybe there's no interaction or maybe there is a great deal. It will depend on the facts and the particular treaty.
I suppose, given that, the UK is one of our older treaties and some of the others, it might fit into the treaty reform process, if that's what we can call it, if that might happen in Treasury, as to whether some of the language in those older treaties might be updated to reflect the PPT or the MLI approach. Jock also made a comment about, just to add in, it's also about anti-avoidance. So Part 4A is far more prescriptive in terms of the factors to consider. Of course, there's no guidance in the treaty really about principal purpose test and which factors, or 8 objective factors or matters and so on, that one has to think about. So that's also a difference. Yeah, Greg.
Perhaps I misunderstood the question, but my understanding is the principal purpose test would supersede all of the main purpose tests.
Yeah, they're taken out of the treaty, I think.
So it is an interesting question, isn't it? So the MLI does not amend the existing treaties?
No, it doesn't. It modifies their application. So you need to look at the treaty and the MLI side by side. Yeah, so it doesn't actually amend them.
No. Well, and this is the really wonky question you get into, because if something depends entirely for its existence as a matter of law on a different act, in this case, the different acts are the MLI and the existing covered tax agreement. There's a case referred to as the death penalty case, Reed Wakeem, which says from an Australian law purpose that to be read together and interpreted as a single instrument. The day-to-day use of that principle in tax land is the Income Tax Transitional Provisions Act and the 1936 Act and the 1997 Act. And this is what I think is a really wonky question. How do you read alongside the MLI, which clearly depends for its existence on the covered tax agreement, while technically reading it as a separate agreement? And I'm not sure if it will ever make a difference, but it's depending on the facts and depending on the question, I'm not sure if it does. And so that I think is an interpretive issue, which is trouble ahead in the same sense that the SATYAM issue was trouble ahead 20 years ago.
Yeah.
One day we'll have to consider it.
And the fact that the MLI doesn't actually amend treaties is why you haven't seen commercial publishers publishing consolidated text, because there is no such thing. And you can't actually, transport the MLI text into the treaty in a very simple way, in the way that you could, with a protocol, for example, just update the existing text. It doesn't work that way. So I think the last CCH publication was in about 2016, and we haven't seen any consolidated treaty texts appear commercially since then.
The Thompsons do, but they just copy the ATO synthesized text.
Right. Yeah, which is not quite the same.
No, exactly.
So just to come back to this issue of alongside and, principal purpose and main purpose in an older treaty, but which is a covered tax agreement for the MLI purpose. So here we are. But then you're confident that it does supplant the main purpose. That's the intention of the MLI, is to do that, of course.
Yeah. As part of, when we signed the MLI, when any country signed it, you had to notify the provisions in your bilateral treaties that would be impacted by the MLI. So that was a very painstaking process, which we went through in relation to all of the articles, looking at compatibility and so forth. So we would have identified the main purpose tests in all of our treaties when sort of talking about the principal purpose test. So if you look at our notifications, which are on the OECD website, you will see long lists of treaty provisions that are affected by the MLI.
So Greg, does this mean somebody should produce some sort of consolidated authoritative text of how each treaty now exists alongside the MLI?
I think the OECD itself was going to do something like that, but maybe it's just too...
Well, the OECD developed a template that countries are following. So the ATO is now producing synthesized texts, but they're using the OECD format. So it's just, from memory, it's just the existing treaty with sort of boxes inserted at the various points where the MLI intervenes.
Yes, without actually changing the language of these sections as such, of clauses as such.
Correct.
They do say, in this case, forget about the old one, basically, because it's
the new world.
Well, it's in addition to or in lieu of. So, so when you've got in lieu, that sort of is suggesting throw out the old, put in the new kind of thing.
Yeah. Damien Prisher has just commented, of course, that the synthesized texts are really helpful. So we do like those synthesized texts. So look, I'm conscious of our time. We do have just a couple more kind of comments or questions. What I might do is just observe those to the panel and then give you each a chance either to respond or to wrap up. So Mark Brabazon has observed that, we do have 3 treaties with what he calls super saving clauses that exclude anti-avoidance rules from the impact of treaties, with a list of those rules, the MCAP CFC transfer of trust rules. So the UK in 2003, Germany in 2015, and Israel in 2019. The super saving clause is for the Australian law, that's in that case, is to save that law from being undermined, I suppose. So he's asked the question about whether we need a new treaty policy strong medicine with a question mark. Not quite sure what Mark means about that, actually. So that's one possibility, is this idea of sort of, I guess, saving whole parts of our law from treaties, in a sense, if I'm understanding Mark correctly. And Niv has also asked a rather specific question about Division 815B. Can there be situations where you could recharacterize a transaction under 815B? Of course, there's transfer pricing rules, but not under the relevant treaty. So would the treaty prevail to exclude the operation of 815B? So about the interaction of the treaty with 815B. Mark's just said he's too cryptic, and I agree. So look, one comment there about super saving clauses in treaties and whether we keep going with that in the future, and one about that interaction between Div 815B, transfer pricing rule, and treaty, and whether the treaty might prevail to exclude 815B. I might just turn over to our panel to respond or wrap up with any comments.
I'll say something, Miranda. I think it's unfortunate that we're now just carving out our anti-avoidance rules, but we'll see what happens. But on 815B, it's got 815-130, which is effectively the substance over form. And Justice Davies, although she was dealing with 815A rather than 815B, has already said, no way, Jose. Be interesting to see what the full federal court says in the decision, hopefully soon.
I was going to say, Richard, I think Justice Davies said that if we're thinking the same passage of Glencore, that there are recognised situations where you can recharacterise, but none of them were present. And I think that is possibly a problem with the Commissioner's pleadings in that matter, because it'd be easy to recharacterise the arguments that they made substantively as fitting within the particular OECD TP guideline exceptions to recharacterisation.
Maybe we will see something different on the appeal. Greg, final comment about, the joyful future of tax treaty negotiation, or responding to either of those questions?
Excuse me, I won't respond to those, but I'll just quickly say, I think for me personally, the most interesting part of the MLI was arbitration. So we had arbitration rules in 3 of our treaties, but those rules were different in each treaty and haven't been used. Now we have arbitration, or we will have arbitration rules, I think, in 13 of our treaties. It may take a while before those rules ever get used, but I think one day they will. And that's for us, that's a whole new ballgame.
And it is a new constraint, I think, on treaty process, which Australia really hasn't had, not on negotiation, but on process of application for taxpayers.
I think it'll encourage a lot of competent authorities to resolve their disputes within the 2-year period.
Right. Well, look, I'm conscious we're out of time. So thanks very much to everybody for joining us for this EFA webinar. Thanks so much to our panel, Gareth Redenbach, Richard Phan and Greg Wood. Really interesting topic, and we do look forward to the rolling out of this the brave new world of treaty negotiation with, what was it, $2.9 million?
3.9.
to support, we need at least 20 treaties coming out of that, Greg, I'm afraid. So you've got to get moving. Thanks a lot to everyone. We are recording it, and we'll let you know when that recording is available. Okay. Have a good evening.
Thanks, everyone.
Thanks, everyone.
Thank you.